Hello, kings and queens. This is Zena at Wealth and Success Business Enterprises. I want to thank you for viewing my channel. Please give me the thumbs up, like, share, and subscribe. I am here to talk to you about wills and trust accounts. I did say about a week ago that I was going to be providing information on wills and trust accounts, and I want to just share what is the difference between a will and a trust account. A will has to go to probate court. You have to go to probate court with a will to file a petition. With wills are public information. Wills disclose how much money or assets you have. It discloses what type of property you have and the property value amount. It discloses debt. You have debt. A will is public information. It is posted in the courts, public record information. So with a will, it's public, and the information is shared. Okay. For instance, you have a will designated for your child to be the beneficiary, and you have bank accounts for that beneficiary, and you die. Say you die and you have your child listed as the beneficiary on your bank accounts with the will. This is with the will. And so that child that is designated as the beneficiary will need to go to the courts to go to probate court to file a petition. And dealing with the courts, there is fees. I don't know what the price is to fill out a petition, because every form that you fill out, they want to charge a price. So I don't know. I don't have the pricing for the petition you would need to fill out. You would need to contact your court, or what state or what county you live in. And so a petition needs to be filed because you have a will. And so with that petition that you're filing, you want to say that, look, my mom or my dad, they left me this property, they left me these assets. There's this will, and so I'm here in probate court, and I want to get this legalized. So when I go to the banks, they will allow me access, because everything has to be cleared through the probate court, where the judge makes the final decisions. You just can't go to the bank and say, look, I got this will, I got this information, my mom appointed me as beneficiary over these checking accounts, savings accounts, and I want to receive access. So but the bank is just not going to just give you access to those accounts if nothing is stamped by probate court and not confidential, but in the official form that will allow the banks to release the accounts to you. Okay, even if you don't have a will, you must go through probate. Even if you don't have a will, you must go through probate to provide all the necessary documents that are needed in probate to establish that you are the beneficiary, the person to inherit what your parents have left you. And then, like I said, the judge makes the final decision on if you are going to receive the inheritance of the assets that have been left to you, whether it's homes, property, accounts, etc. With the will and probate, if you have siblings and your parent noted you as the only beneficiary and no other siblings, the siblings must be notified. Okay, say you have about 5 siblings and your parents or your mom or dad only designated you as the beneficiary to inherit the assets of the account. But you have to notify your siblings. They have to sign off on the document, on the petition, stating that they have been notified, that they are aware that you are the only beneficiary. Because if you don't have this information completed or filled out, that the judge or the courts will not accept your petition, because they're going to ask, are there any other siblings, brothers and sisters in your family? You have to notify them all to let them know that you are the only beneficiary, or if there's more than one beneficiary, everyone needs to be notified, especially when it's going to probate. They must sign off on the petition, and a trustee is the person or entity legally responsible for managing the assets in a trust and distributing the property according to the trust terms. A trust is the person who creates the trust. An executor is the person you name in your last will and testament to carry out your wishes after you die. So let me read that again. A trustee is the person or entity legally responsible for managing the trust. Say your mom or dad, they have a trust account and they appoint a trustee. The trustee is the person that pays certain things out, make sure that this person gets that. They are the person that manages that trust, okay, and the assets in the trust, and distributing the property according to the trust terms. So they are the ones that are going to say, here, you get this property, you get that property, because your parents have designated a trustee to be the manager of the trust account, okay? And the truster is your parents, your mom or dad, who created the trust account, okay? An executor is the person you name in your last will and testament to carry out your wishes after you die. So executor is somebody that is going to carry out the last wishes that your parents have requested after they die. Trustee duties. The trustee's duties may be a page long or 30 pages, while the person of the revocable trust is alive, and you are the beneficiary, you are not entitled to any information until that person dies. So if there's a trust account, you are not entitled to find out about how much money is in that trust, or what type of property the value of the accounts are. You won't find this out until the person dies, who is the owner of the trust. But it does say that the trustee may give you a copy of accurate information of where property that you're going to receive, and permit you to inspect and to view the documents of that trust. So you will get a copy of it, but as far as finding out what is the value, how much you're going to get, all of that will be given unto you after the person dies by the trustee. Sorry about that. Okay. Oh yes, I didn't give my disclaimer. My disclaimer is that I'm just here to provide educational information. Anything that I'm saying is on an educational basis. This is not something that is binding from me. This is binding, meaning that is binding, is illegal. What I'm saying or the information that I'm giving is binding. This is on educational purposes. This is on me doing research. So anything that I'm saying is strictly for education, strictly as for advice, and that's my disclaimer. Okay. Okay, okay. You have, if somebody wants to give you or will you or make you a beneficiary and to give you certain inheritance, real estate, homes, cars, money, bank accounts, that you have the right to denounce that. You have the right to disclaim that. Just because somebody lists you as a beneficiary on any type of accounts, you have the right to denounce it. You don't have to accept it. In California, you have 90 days. No, you have 9. Let me see. I believe you have 9 months to. You have a 9-month window to denounce receiving any beneficiary inheritance from somebody that you don't want to receive it from. So you do have that right. Because sometimes when someone is making you beneficiary of something, you don't know if you're taking on bills, you don't know if you're taking on liabilities, you don't know if you're taking on somebody's gambling debt, you don't know what type of debt that someone may be gifting to you that you're going to have to take care of. So that's why it's, always good to always find out, well, when you've been a beneficiary, what did they have debt, or what am I really receiving? Okay. Like I said, a trust is private. A trust is not filed with the courts. A trust is not public information in regard to a will. With a trust, your information is not public. It doesn't disclose how much money or assets you own. It doesn't list the value of the property or estates. And also with the trust, trust, can cost up to like $3,000, $4,000. Basically, they are people that are experienced. Basically, they are people that are attorneys that write up your trust account. But I know some people that have done their own, and it's simple. You can go to Staples and you can purchase the documents for your trust account. They have them at Staples. They have it at any Office Depot location where they have the trust account applications that you can fill out instead of paying $3,000. And like I said, it's public. My friend, she did her trust account, and I said, well, did you file it with the court? She said no. And she said the only thing I did was I got it notarized. And she said I didn't even file it with with the county register office. You know, the county register office, that's the office where you go when you want to apply for your fictitious business name, and you want to apply for your business account. And you can also, you know, get anything officially documented at the county register office. And she said she didn't do that. So you are able to create your own trust account with those forms. Just make sure you have everything listed and noted accurately, and you want to make sure that it's revocable, because a revocable means that you can list people in there that can make changes. If one sibling dies, then the next sibling can be next in line to make to handle that trust account. And because with irrevocable, there's no changes, meaning that no one can make any changes, that the owner has made specific details and guidelines on how they want this trust to orchestrate or to be managed by the trustee. So it's best to get a revocable trust. I went to a seminar and they said that is very important, that you want to have a revocable trust, because if it's irrevocable, no changes cannot be made. Okay. With the trust, a person's money continues to be useful after they have placed it away. You can place real estate, cash, or valuable assets in your trust. A revocable trust can cost a few $1,000, like I just stated. So you want to, you can do your own, or you can pay to have someone do your trust for you. If you're uncomfortable on doing it yourself, you can always pay someone to have your trust done for you. Okay, and with the trust, you can put your antiques, your art, anything that's valuable, jewelry, anything in your trust account. Okay, so yeah, that's information that I have on the will and trust accounts. A will, can be drawn up by anyone, or you can go to a professional, or you can create your own will. You can design it, you can draft it out, or you can have lawyers do it, because right now everything is basically self-taught. You can pay those $1,000 to have it done. You do that will, you go get notarized, or you can take it to the courts and have it filed in the courts, after you have done that. And you can I don't know if you can take it to the county register and have it documented there. But right now, today, people are being self-sufficient, and that's what it's all about. And God wants you to be self-sufficient. Anything you don't know, you can go to the library, research it. Those librarians are there to help you and guide you and pull those books down and go through the indexes and get all the research that you need. You can Google stuff. You can watch YouTubes. You can teach yourself, and you can also with the trust account, you can put your property up under there. Say, because I went, like I said, I went to the seminar, and this gentleman who was doing the seminar, he was saying that with the say, you know, you have property, and and you're living in your property, you want to put that property under your trust account. Okay, in the event that you die and you don't have any protection, and that your property is going, it's not going to go in probate, it's not going to go under your trust, it's going to go to probate, meaning it's going to go to the court, and the judge is going to decide who is going to get that property. If you don't put it in a trust, under the trust you have people listed. The trust is going to go to such and such, or the trust, the property is going to go to this person. With the will, the judge is going to decide on who's going to get the property. If there is no will, if there is no trust account, and with the will, you still got to go to probate court, because it's public. It's going to be, whatever you do with the will, it's going to be made public, and that's how it goes. Like with the trust, it's private. Don't nobody know your business. It's a private document. It's private information. Only you and certain people know. And so the judge, cannot touch your trust account, because it's private. And so, yeah, so basically, you own some property, put that property in your trust account. In the event that you die, the court won't take it and give it to whoever or whatever. So this is my information I want to share with you guys regarding the trust and the wills. So I was watching one lady's video, and she was saying that it's good to have a will. It is. It's good to have a will, to have some type of information. Okay, so I hope you like this video. Thank you for liking. Please share, subscribe, and like. Thank you so much. This is Zena at Wealth and Success Business Enterprises. I thank you so much for viewing my video. Have a wonderful day. Take care. Bye-bye.